and welcome to the latest episode of People Matter. When is a resignation not a resignation? For example, if an employee puts their keys down on the front desk, says "I'm done" and walks out, would you think they'd resigned? Well, this was a question that the Employment Tribunal needed to consider recently, and the case provides a useful reminder of the dangers of assuming that an employee has resigned when in fact they may not have done. In the case in question, the employee was upset because a colleague had accused her of bullying. She was also upset about some medical issues. She had a meeting with the business owner and said she might resign, but didn't actually resign. The next day was due to be her final day at work for a few days before she went on annual leave. Previously, before going on annual leave, she'd always handed in her keys. On this occasion, she went into the office. She was very upset about the bullying accusation and her medical issues and was visibly shaking. She put her keys down on the front desk, said "I'm done," made a gesture to indicate she was done, hugged her colleague and left the premises for the rest of the day. The colleague told the business owner that the employee had resigned. The next day, the employee got in touch and said she'd be submitting a fit note for the next 2 weeks. Towards the end of the period of the fit note, the employee asked for a meeting with the business owner and asked to come back to work when the fit note expired. The business said that the employee had resigned and refused to allow her to return. The employee disputed this and put in a claim for unfair dismissal. The Employment Tribunal therefore needed to decide, had the employee resigned or had she been dismissed? It reminded itself of the principles applying to resignations, which can be by words or by way of conduct and the surrounding circumstances, or both. The basic position is that unambiguous words of resignation will constitute a resignation, even if the employee didn't really mean them. However, in some circumstances, including in some cases where words are spoken in the heat of the moment, an employer should not assume that that constitutes a resignation. In addition, if ambiguous words are used, the employer should check what the employee meant. A tribunal will consider how a reasonable employer would have interpreted the employee's words, and any ambiguity will be used against the party seeking to rely on those words. In the case in question, the tribunal decided that the employee had not resigned. She had previously handed in her keys before going on annual leave, so this did not equate to her resigning. She didn't use words that indicated she was resigning, and her conduct was ambiguous. She was clearly very upset. She also, the following day, sought to submit a fit note, which was inconsistent with having resigned. The tribunal was critical of the employer for not having checked whether the employee had resigned or not, and simply relying on a colleague's statement that the employee had in fact resigned. So, having decided that the employee had not resigned, the tribunal needed to consider whether her dismissal had been fair or not. The employer stated that the employee had left their premises without permission and that this constituted gross misconduct. The tribunal disagreed and found there was no other fair basis on which the employee could have been dismissed. Therefore, the dismissal was unfair, and the employer was ordered to pay the former employee compensation. So where does this case leave employers? Well, the key lesson to draw is clearly that if an employee may have resigned but it's unclear, an employer should check in with the employee as to what they meant, ideally after a short cooling off period. That way, the employer cannot be deemed to have dismissed an employee who they thought had resigned but actually hadn't, and can avoid a finding of unfair dismissal and an order to pay compensation. If an employee has not resigned and an employer no longer wishes to employ the employee, they will need to consider the options open to them and the rules which apply to dismissals, including, in the case of employees with more than 2 years' service, the need for a fair reason for dismissal and to follow a fair process to avoid a finding of ordinary unfair dismissal.